Hi guys, welcome to my channel once again. This is Bar Talk with Ola and my name is Mujela Olua. Today I want to talk about a very important topic. It's as important as it is very controversial and quite sensitive, especially in my part of the world, Nigeria. I want to talk about divorce, dissolution of marriage. I know that there are, a lot of persuasions and opinions about divorce. There are spiritual, religious, emotional, social constructs and beliefs and dispositions to the subject of divorce. But today I want to talk about it from a legal perspective only. I want to tell you what the law says about divorce, how you can get divorce, and the things that can come in the way of you instituting a successful divorce suit in court. So I would be using the word divorce and dissolution of marriage interchangeably, but essentially I want to talk about dissolution of marriage. Under the Matrimonial Causes Act, you could ask for different decrees from the court regarding the contract of marriage, and the decrees are as follows. You could ask for the dissolution of a marriage. You could ask for the nullity of a voidable marriage. You could ask for the nullity of a void marriage. You could ask for judicial separation. You could ask for restoration of conjugal rights, and you could ask for justification of marriage. But today we'll be talking about dissolution of marriage. Under the Matrimonial Causes Act, there's just one ground for dissolution of marriage, and that is that the marriage has broken down irretrievably. To ask for dissolution of marriage before the court, you have to come by way of petition. It's called petition. The person bringing the petition is called the petitioner, and the person to whom the petition is addressed or whom the person is asking the court to divorce them from is called the respondent. There might be co-respondents depending on the facts that you're proving before the court to ask for an order of dissolution of marriage, but essentially the parties are called the petitioner and the respondent. There might be co-respondents. Regarding jurisdiction, you could come before any high court of any state in Nigeria to institute divorce proceedings. That's because the entire Nigeria is one jurisdiction when it comes to matrimonial causes. So for divorce proceedings, you could come before any state high court in Nigeria, across Nigeria. It does not have the restrictions of maybe the place where you live, the place where you work, or the place where the marriage subsisted. It does not have that restriction. Matrimonial causes do not have that restriction. So you could come before any court in Nigeria, any high court in any state in Nigeria to institute divorce proceedings. The only ground for dissolution of marriage is that the marriage has broken down irretrievably, and that can be found in section 15(1) of the Matrimonial Causes Act of 1970. That's the law that guides marriages, the construct of marriage, and the deconstruction of marriage, so to speak, in Nigeria, the Matrimonial Causes Act of 1970. So in section 15 subsection 1, it states that the ground for dissolution of marriage upon which or under which any party can come is that the marriage has broken down irretrievably. However, there are some facts that you need to prove. They are also set down in that law. In section 15 subsection 2 of the Matrimonial Causes Act 1970, the facts that must be proven in support of the ground that the marriage is broken down irretrievably are all listed, and a party must prove at least one. You can bring 2 or 3 of the facts or as many as are applicable to your case, but you must prove at least one of those facts before you must prove it successfully before the court can grant an order of dissolution of marriage. I'm going to read out those facts to you and maybe provide a brief explanation on each and every one of them. The first one is that the respondent has willfully and persistently refused to consummate the marriage. That simply means that the parties have not had sex, since they got married under the law. And before I move on, I'd like to say that, bringing an order of dissolution of marriage only applies to marriages that are contracted under the act. So it does not apply to customary marriage. It does not apply to cohabitation. It only applies to marriages that are validly contracted under the Matrimonial Causes Act. So the first fact that can be proven in support of the ground that a marriage has broken down irretrievably is that the marriage has not been consummated. Maybe one party has persistently and willfully refused to have sex with the other party. That simply means that, you know, there has been demands for sex and one party has been refusing willfully. That means that they are able, but they are just not willing to have sex with the other party with whom they have been joined in marriage. So that's the first ground, that one party has willfully and persistently refused to consummate the marriage. The second fact is adultery, and that the petitioner has found it intolerable to live with the respondent. That means that one party has been committing adultery in the marriage and the other party cannot, you know, condone the adultery. So it's different if it's something that you can condone, if it does not go beyond, you know, your tolerance level or your endurance level or whatever, whichever way you'd like to put it. So if one party has been committing adultery and you find it intolerable to live with their adulterous behavior, you could come under this fact to ask for dissolution of marriage. Now, this is often difficult to prove because there has to be a co-respondent. You have to show the court who the co-adulterer is. You know, adultery is having sex outside the marriage with one married party and another party who's probably married or not married themselves. So if you're saying that the other party in your marriage or in their marriage has committed adultery, you have to bring the adulterous partner before the court, and you have to prove to the court that they have actually committed adultery. There must be, you know, cogent proof before the court that they are actually committing or have committed adultery, and that you find it intolerable to live with your spouse. So for adultery, condonation might be, you know, a clog in the wheel of the success of coming under this fact. That means that, you know, if you've condoned the adultery, for instance, if after you've caught them in adultery and you found it intolerable to live with them, you have now consequently had sex with them, you have condoned the behavior. So it might make it difficult for you to prove a successful case of adultery before the court. So it must be certain and it must be clear that, okay, this person committed adultery and you have not had sex with them afterwards. That is, you find them so repulsive, you can't even stand them or have sex with them any further. And that's why you're coming before the court to ask for a decree of dissolution of marriage, proving the fact of adultery. The third fact is desertion between the period of 1 year before the petition was instituted in court. That means that one party has deserted the marriage at least for 1 whole year before you brought the petition to court. Desertion means the party has left the marriage. They might have left the country, left the state, you know, abandoned the matrimonial home. So desertion for 1 year is one of the facts that can be proven in support of a prayer for a decree of dissolution of marriage. The fourth fact is that both parties have lived apart for a period of 2 years and the petitioner is not opposed to a decree of dissolution of marriage. That's self-explanatory. The fifth fact is that parties have lived apart for a period of 3 years. So if both parties have lived apart for a period of 3 years, without more, the court will grant a decree of dissolution. As soon as the petitioner can prove that both parties in the marriage have lived apart for a period of 3 years before the petition was instituted, a prayer for a decree of dissolution will succeed. The sixth fact that can be proven is that a party has refused to comply with a decree or an order for restoration of conjugal rights for at least 1 year. So let me provide a brief explanation. There's a decree for restoration of conjugal rights. Like I said earlier, that's one of the decrees that you can ask for in the matrimonial court. It just means that you're asking the court to compel the other party to fulfill their conjugal obligations to you in the marriage as the husband or the wife. So if the court has made this decree or order in the past and the other party to whom the order was, you know, addressed has not complied with it for at least 1 year, you can come before the court and ask for a decree of dissolution. And once you can prove it, it will succeed. And the last but not the least fact is presumption of death under the Evidence Act. Under the Evidence Act, presumption of death comes into play after 7 years. So if someone has not been found, you can't find them for 7 years. Probably they deserted and they did not look back, or they got missing, or got lost, or you lost communication, or they just took off and left for 7 years. After 7 years, the law presumes anyone that has not been found dead. So the presumption of death is one other fact that you can come under to ask the court for a dissolution, a decree of dissolution of marriage. So if the husband or the wife has left for 7 years and has not been found, has made no communications, and it's been impossible to communicate with them or trace them, you can come before the court and ask for a decree of dissolution of marriage. So those are the facts that you can prove before the court in order for your prayer for dissolution of marriage to succeed under the Matrimonial Causes Act 1970 in Nigeria. Now you can bring 1, 2, 3, 4, or as many of the facts as are applicable to your case and as you can prove, but at least you must prove one before your prayers before the court will succeed. Now there are other things that we need to look at, when bringing a prayer for a decree of dissolution of marriage before the court, and I will talk about them in turn. In addition to these facts that I've spoken about, by section 15 of the Matrimonial Causes Act 1970, subsection 3 provides some further, reasons which can be proven before the court for a decree of dissolution to succeed. And one is that a party or a petitioner must be able to prove before the court that the other party has committed sodomy, bestiality, or rape in the marriage. So if they're able to prove any of those three, a decree of dissolution will also succeed. So those are the facts that can be proven before the courts, before the court will grant a decree of dissolution of marriage. It's important for me to mention at this point that in Nigeria, courts are very reluctant to actually grant a decree of dissolution of marriage. So you find that you go to court sometimes and the judge is giving a very long adjournment, hoping that the parties would settle along the line. We even read about a case online whereby they had instituted the divorce before the COVID-19 lockdown, and then afterwards when they came to court, the wife was already pregnant, and they told the court that the wife's pregnancy is proof that the parties have settled because they have come back together. So there are judges that hope that this might happen, before they grant a decree of dissolution. So they do things like, advising the parties, trying to propose peaceful settlements, or mandating the parties to explore ADR before they go to trial, or they give long adjournments, hoping that, the parties would settle at some point in time. But if the parties cannot eventually settle, once they're able to prove their case before the court will grant a decree of dissolution of marriage. So that's just, I think that's just a societal leaning or disposition. It's not necessarily the law that the court should be reluctant. But of course, that it's very important to protect the sanctity of the institution of marriage. So there's a 2-year rule by law that says that you cannot bring a petition before the court for a decree of dissolution of marriage if the marriage is under 2 years. So it's called the 2-year rule. And the 2-year rule is that you have to wait for 2 years before you can bring a petition for the dissolution of the marriage. But the court will still allow the petition before 2 years if you can prove to the court that not granting the order or the prayers at that time would work hardship on the party that's bringing the prayers before the court. So the court will allow the petition if the party bringing it can prove that, refusing the petition will work exceptional hardship on them. For instance, if the other party is so depraved that they cannot continue to live with them until the expiration of the 2 years, they can actually, prove their case before the court for the court to allow the petition and the divorce proceedings to go on. So a decree of dissolution will be granted if a party can prove the facts that I've mentioned earlier, if they can prove that there's been a willful and persistent refusal to consummate the marriage. I've explained what that means. If they can prove sodomy, bestiality, rape, adultery, and then if there's a cross petition. So that's another interesting point. So when a petitioner brings a divorce petition to the court. I've told you that the other party is the respondent. Now, the respondent is supposed to reply by way of a reply to the petition. But aside the reply, they can also bring a cross petition. A cross petition is like the respondent's own petition, which they are bringing not because they want to institute a fresh case of divorce, but because you have brought your own, and they also have things to ask for before the court against you. They are bringing it alongside their reply to your own petition. So that's a cross petition. So the court might grant a divorce, a decree of dissolution of marriage, which is also a divorce. I told you that I would use it interchangeably. So the court might grant it even if your own petition does not succeed and the cross petition succeeds, and the order being asked for is divorce, is a decree of dissolution of marriage. So the court might grant it, will grant it. So those are the facts that must be proven before the court, and those are the instances in which case the court will grant a decree of dissolution of marriage. Now, there are a few things to note about dissolution of marriage in Nigeria. And that's that, well, I know that there are parties that like to spring surprises on the other parties. So they wouldn't want to serve them. They want to shock them that, oh, the court has granted a decree of dissolution. Oh, we are no longer man and wife. Maybe because they feel that the other party is enjoying one benefit in the marriage and they want to deprive them of that benefit. And then they bring a petition to the court. The court will not assist you in springing surprises on the other party. And that's why service is very crucial in divorce proceedings. There must be proof before the court that the other party has been served the petition, and they have a window to reply or to not reply, or to even reply and bring their own cross petition. So you can't spring surprises on the other party. I know that there are people who probably rent other people to act as their husband or the wife in divorce proceedings so that they can get a judgment against their spouse even in the absence of the spouse, and then they spring a surprise on them. That's unlawful. If found out, that's very, very grave an offense, and it can land you in serious trouble. So do not do that. If two parties that came together and married each other decide that they want to go separate ways, or if one party decides that they want to go separate ways from the other party, it's only decent and necessary and lawful for you to inform them. Even if you're not informing them informally, inform them formally by serving them the petition, ensuring that the petition is served on them. Now, if the other party is not in the country, you can still arrange for service. But if it's impossible to actually serve them, which is a very possible scenario, if it's impossible to serve them, you come before the court and apply for an order of substituted service. So once the court grants that order, you can serve them by substituted means provided by the court, and there will be proof before the court that you were unable to serve them personally, and then you have arranged for substituted service and they've been served by that means, and then the case can continue. So if you're wondering why some divorce proceedings or divorce petitions pended before the court for a long time, or were not as fast as you thought it would be, I watched a video. That's exactly why I'm making this video. I watched a video, and then the lady kept claiming that a judge sat on the matter. Somebody filed a divorce proceeding that she was insinuating that it was because the person was a woman. That's why the judge sat on the matter and did not allow the proceedings to go on. And then the husband later filed their own divorce, filed for a divorce, and then the court sat on it and granted the order, and even fined the woman's new lover, for adultery. You probably already know the case I'm talking about, but I wouldn't say that I really know or understand what went on in that matter. But I'm just saying that one thing that could have happened is the issue of service. It could be that the other party evaded service for so long. So if the other party is evading service, instead of allowing your case to pend in court, all you need to do is ask for an order of substituted service. And once you've done that, the case can go on. And another thing is defended and undefended divorce proceedings. Defended proceedings is the one in which the other party replies or probably cross-petitions you after they've been served. The undefended one just means that you served them, they received it, but they never responded. Like they just said, just go on and do whatever you want in court. So there are some cases been in a subsequent matter between the ex-husband and the ex-wife. During the divorce proceedings in another court, the husband did not show up, did not pay attention, did not even did not defend or contest the divorce, and the order of divorce was given. And then alongside other things, the prayers of the woman was granted, and she was granted custody of the child. That's when the husband now sat up and realized that, oh, this is serious business. I want my son back. And then he started doing some other things that led into another matter, a criminal matter in this wise, which I was involved in. So undefended just means that the other party has refused to respond, or they are not even interested in defending the claims that you have brought against them before the court. So if there's proof before the court that the divorce proceedings is going to be undefended, that the other party has not responded within the window which the law has given them to respond, you are allowed to come before the court, and you will file a certain form at the registry, and then the court will allow the proceedings to go on. One thing to note about divorce proceedings is that there's no default judgment. So you can't say because the other party did not show up, or they did not reply, or cross-petition or something, you want the court to just grant your prayers. No, you have to prove your case before the court. It's like in land matters too. You can't just come and claim someone's land, and because the person has not responded or has not shown up in court to antagonize you or to defend themselves, you now ask the court to just grant your prayers. No, you have to prove those things before the court. The facts under which you're coming, for the ground that the marriage has broken down irretrievably, you have to prove those facts before the court successfully, even in the absence of the other party or their lawyer, before the court can grant an order of dissolution of marriage. So that's it for defended and undefended divorce proceedings. Also, I'd like to say that in the case of willful and persistent refusal to consummate a marriage, sodomy, bestiality, rape, adultery, and cross-petitions, the 2-year rule will not apply. It will not apply. So if there's, for example, if there's been a petition and there's a cross-petition, the court will not say that the cross-petition should wait for 2 years. No. If there's a petition and the cross-petition is coming alongside, the reply is not bound by the 2-year rule. And then in cases of sodomy, bestiality, adultery, rape, and willful and persistent refusal to consummate the marriage, the 2-year rule will not apply. I want to talk about the 3 C's. That's condonation, connivance, and collusion. So a prayer for a decree of dissolution of marriage might or will not succeed if the court finds any of these things. If the court finds the petitioner or the respondent guilty of any of these 3. So condonation means that the fact that the petitioner is proven before the court, or maybe the cross-petitioner is proven before the court, for instance, that there has been willful and persistent refusal to consummate the marriage, or, for example, adultery. If the court finds that they have condoned that act, for instance, maybe there's been adultery for like 7 years, and each time the person goes out, commits adultery, comes back, you still go on and have sex with them, and you have condoned that habit. If there's proof before the court that you've condoned the act of adultery, your prayers for an order of dissolution might not succeed. And connivance is if the court finds out that the petitioner and the respondent are conniving to ask for a decree of dissolution. For instance, there are people that they need it to serve their own selfish interests. So if the court finds out that both parties are conniving to ask the court for a decree of dissolution so as to serve their own selfish goals, for instance, maybe you need a proof of divorce for some pecuniary gain, or to get something somewhere or somehow, if the court finds out that that's why you've connived with your spouse to dissolve the marriage, to have the marriage dissolved, your prayers before the court will not or might not succeed. That's 2. And then collusion. It's just like connivance. If the court finds out that you're colluding with the other party, or you're colluding with any other party, for to ask the court for a decree of dissolution for some other selfish or ulterior motives that are not in accordance with the law and the stipulations of the law and the sanctity of the institution of marriage, your claims before the court might not succeed. So the things that might be found to be connivance or collusion are not really set in stone, but the court will decide based on what is put before it and based on what it can deduce from the conduct of the trial. So make sure that there's no condonation, there's no connivance, and there's no collusion when asking for a decree of dissolution of marriage. The sanctity of the marriage is protected by no other law or rule or body as the Court and the Matrimonial Causes Act. The Matrimonial Causes Act is very, very particular about protecting that institution of the society, because it's almost, the foundation on which the society is built. So contrary to what people think, that, oh, the court wants to dissolve people's marriages, the court does not want people to stay married. The court actually wants people to stay married, and the court wants people to respect and protect the institution of marriage. That's why there are so many rules and regulations and a lot of what would appear as hurdles that a party or parties have to cross before they can get a successful decree of dissolution of marriage. Now, another thing is, when the trial has been successfully conducted. No, before I say that, let me note here that the conduct of divorce proceedings must always be in open court. There are judicial decisions on this. So once you have decided that you want to ask the court for divorce, it has to be in public. Of course, the marriage was in public too. So, the end of it too is mandatorily in public. It's mandatorily done in public. Now, that doesn't mean that the whole world has to know about it. It just means that it must be conducted in open court. So if, for example, you have, I was in court one day, and there was a divorce proceeding going on, and the man was trying to hide. He was trying to speak in parables. He was saying something about the wife. He did not want to speak directly. The court kept prodding him until the court now became impatient. That what is this thing that you keep referring to with, such a coded reference term? You have to speak plainly before the court. Once you're in court for divorce proceedings, everything has to be plain and clear before the court. So before a marriage results in a divorce, it's important to go for counseling, and then you can choose ADR. There are alternative means of dispute resolution that doesn't have to end in litigation. But if it ends in a divorce proceeding, it has to be in public and in open court. There's even a Supreme Court decision that says that you can't ask for the trial to be conducted in the judge's chambers. All the court can do for you is to empty the court. That is, ask everyone that's not a part of the case to get out of the court at the time when the trial is to be conducted. But it must be conducted in court, right there in court. So whatever you want to state, you state. So that's why, like I said earlier, judges try to prevent going to trial in divorce cases, so that the dirty secrets of the marriage, which you need to, now bring before the court to prove one fact or the other according to the provisions of the Matrimonial Causes Act, you would not have to divulge them. I'm so happy that I was involved in a divorce proceeding about 2 years ago, and we were able to avoid going to trial. So the court ordered, after we had gone back and forth, and settlement became impossible, the court ordered settlement meetings for us to agree on some terms concerning child maintenance and a few other things. And then so we had a series of ADR meetings. They were not the easiest, both parties were aggrieved, but we were able to reach a consensus on how the children were to be taken care of, and how the disputed properties in the marriage were to be shared or owned going forwards. And then we brought that before the courts, and then the court now adopted it as its judgment in the matter. So there might be court-compelled ADR, court-ordered rather, not compelled, court-ordered ADR for the parties to agree on some terms, so that they would not have to go into trial, which might be messy and will be a public record which anybody can access in the future, just to preserve the sanctity of the institution of marriage. After the conduct of the trial, and a party or the parties are able to prove their cases before the court will grant a decree nisi. A decree nisi exists for 3 months. It's not decree absolute, so the marriage still subsists for those 3 months. But the decree nisi will hold for 3 months. If after 3 months things subsist, the parties are still interested in going on with the divorce and they are still alive and all, the court will now order a decree absolute. The decree absolute terminates the marriage and dissolves it strictus sensus, and so the parties can both go their separate ways as the marriage is now dissolved. Now note that if within the decree nisi period, the 3 months, one party dies, the other party is still entitled to administer the properties if the party has died without a will. And if the party has died with a will and they have any portion in the will as the wife or the husband, they can still lawfully inherit because the marriage has not been terminated. But the decree absolute actually dissolves the marriage. So that's how to go about a divorce in Nigeria. I have told you, and I hope that you have heard it, that the law and the courts are actually pro-marriage. They are in full support of the preservation of the institution of marriage. But where things break down irretrievably, there's a provision for the marriage to be dissolved, and there are facts to be proven, as I have said. There's a 2-year rule that also seeks to preserve the marriage by saying that you can't come and ask for dissolution until your marriage is 2 years. But even at that, if there are special circumstances, for instance, if denying you the opportunity to ask for a dissolution will work hardship on you, you can still come and prove your case before the court. If the other party would not be served or would not defend the matter, you can still go and prove your case and get your order of dissolution if the court is so persuaded. And of course, the court will also push for ADR, and you can also go for ADR and counseling, either to preserve the marriage or to agree on some terms that you want the court to adopt as its judgment in the matter. And of course, there must be no condonation, connivance, or collusion between both parties or by one party and another party in seeking an order of dissolution of marriage. And then when the trial is concluded, a decree nisi is granted for 3 months, after which it becomes absolute, and then the marriage is completely dissolved and both parties can go their separate ways. I hope you've learned a thing or two today. Leave me comments in the comment section, share this video, and I will see you in my very next video. Toodles!